Hello everyone, Bob Davie with San Diego Residential Property Management here, and thank you for tuning in to my third installment of our video email series. We certainly hope that you and your family are doing well as we roll into month number 7 of our nationwide COVID-19 response. We're only just now coming off of a very active rental season that ended up being quite busy for us with low inventory and a healthy amount of demand. Back in April, we, like you, did not have any idea how COVID would impact the industry. However, I'm thrilled and proud to report that as of now, with the month of October, we have an unbelievable 100% paid as agreed throughout our entire portfolio of rental properties. In contrast to what several of my colleagues here in the San Diego area are dealing with, we have weathered what appears to be the worst of this pandemic, at least for now. We're hoping and praying that as fall and early spring comes upon us, that we don't have another wave of the spread of the virus, but are, as always, hoping for the best and preparing for the worst. In prior installments, we discussed early on the basic status of COVID-19 and how we as your management company were responding to the ever-changing pandemic. The second installment reviewed some landlord-tenant laws with my friend and attorney Jim Roth as it related to the pandemic. With this installment, we're going to take a closer look at some recent pieces of legislation that have come about, primarily as a result of the pandemic, principally Assembly Bill 3088. I'll also take the opportunity to briefly review the impact that AB-3088 has had on another piece of legislation, that being AB-1482, which was passed into law October of 2019. We'll then close out our video by answering several key questions that have come to me over the last several weeks as it relates to AB-3088. Now, I'd like to apologize in advance for the length of this video, but hope that you find it helpful and informative. So let's get right to it. Assembly Bill 3088, which is known as the Tenant Relief Act of 2020, was signed into law on August 31st of 2020. It's a broad piece of legislation that covers a multitude of items, too many to review in this brief video, so I'm only going to be giving you the highlights. Now, a great way for you to consider AB 3088 is to look at it in two completely separate parts. Part 1 would be March 1st of 2020 through August 31st of 2020. And then the second part would be starting September 1st of 2020 and going through January 31st of 2021. Now, you may think that the March through August timeline doesn't really apply to you because, well, after all, your tenants have all paid their rent. But I still think it's important to review so that we have an idea of what the law says on certain issues that we could be facing during the September through January timeline. So let's take a look at the March through August 2020 timeline. Any unpaid rent during that time frame due to a COVID-19 related hardship cannot lead to an eviction. This rent shall be treated as consumer debt and can be recoverable by a small claims action or, if necessary, a civil action. The limitations that are normally placed within a small claims court have temporarily been lifted. For example, prior to AB 3088, you were limited to a maximum number of 2 small claims cases per year. And you were also limited to a maximum of $10,000 as the recoverable amount. Now, both of those limitations have been lifted. So if necessary, you will be allowed to sue for all unpaid amounts, regardless of the number of cases you bring forward and regardless of the total amount to be recovered. However, no lawsuits can be filed until at least March 1st, 2021. Now let's consider rents that are due from September 1 through the end of January 2021. If a tenant fails to pay rent between that time frame, we need to give that tenant a 15-day notice rather than the standard 3-day notice. And by the way, this is business days, not calendar days. The notice itself must also include what is called a declaration of hardship, which we are responsible to provide for the tenant's use. If the tenant is unable to pay the rent owed, they must sign the declaration of hardship under penalty of perjury and pay a minimum of 25% of the rent owed. If they fail to pay the minimum amount or they fail to submit a signed declaration, landlords are allowed to evict them. Those evictions may begin now. Any unpaid amounts above the 25% shall also be converted into consumer debt, just like the March through August timeline. We may not demand repayment of the unpaid COVID-19 related rent until March 1st of 2021. This is also when you may start filing lawsuits for the money. So generally speaking, if a tenant is claiming that they have been adversely impacted by COVID-19 and as a result, either their income has been reduced, their expenses have increased, or both, they only need to sign the declaration of hardship under penalty of perjury and pay a minimum of 25% of the rent owed during that time frame of September through the end of January. They don't need to supply any proof of their hardship. They just need to sign the declaration and pay the minimum of 25% of the monthly rent. Now, the only exception of not requiring proof of the adverse impact is that within the state of California, the state has classified individuals as what they're calling high-income individuals. High-income individuals are generally those that are making $100,000 or more annually. Now, your tenants have already provided us with income verification, so we know who the high-income earners are, and so we already know who would be required to provide evidence beyond their signed declaration of hardship. So let me make this point crystal clear. Rental amounts due are not forgiven. The tenant remains both financially and legally obligated to pay their rent in full. This bill is not providing the tenant with a freebie, as was originally suggested when the authors of the bill initially proposed it. It is, however, making significant changes on how those unpaid rents are collected and when the collection process can begin. Another interesting point is that other types of evictions, such as forcible detainers or material breaches of the lease not related to non-payment of rent due to adverse impact of COVID-19, can immediately move forward. So AB-3088 specifically addresses financial hardships due to COVID-19, but allows other non-COVID-19 related evictions to proceed as usual, which is good news. Some additional good news is that AB-3088 has some protections available for landlords too. Although these protections are limited and not clearly spelled out within the bill, this is what they say. If the landlord is an individual and the property is a 1 to 4 unit property, such as a single family home or condo, and is not owner occupied, the landlord is entitled to anti-foreclosure protections. So how does AB 3088 relate to the prior bill that was passed, AB 1482? Let's take a look. AB 1482, which is the Tenant Protection Act, was signed into law in October of 2019 and went into effect on January 1st of 2020. The passage of this law was the most significant policy change for the rental industry in about 25 years. Now, many of you are familiar with AB 1482, so I won't go into all the details of the bill here, but simply for the benefit of a reminder, there are two elements of AB 1482 that were the most significant. Number one, rent caps, and number two, just cause evictions. The rent cap portion placed a cap, or the maximum amount that a landlord can increase the rental amount during a 12-month period of time. And here in San Diego County, that's approximately 7.5%. Now, under the just cause eviction section, evictions are divided into two categories: at fault and no fault evictions. At fault evictions are situations where the tenant has violated a specific segment of their lease and are at fault for their actions or activities. Examples are failure to pay rent, material breaches of their lease agreement, criminal activity, refusing access to make necessary repairs, things like that. No fault just causes are when the eviction is not based on the tenant's actions, but rather are due to the owner's actions. Some examples of no fault evictions are, let's say the owner of the property intends to reoccupy the property at the end of the current lease and therefore will not be renewing it. Or let's say the owner chooses to withdraw the property from the rental market altogether. Or let's say the owner wants to complete a substantial remodel, rendering the residence uninhabitable. These are all examples of no-fault terminations of tenancy. The reason I'm going into this level of detail is because AB-3088 impacts AB 1482 and somewhat alters it specifically with regard to no-fault evictions, such as those resulting from 60-day notices to terminate tenancy. According to AB 3088, these may not be filed until February 1st of 2021. Further, this now applies to all properties. You may recall that AB 1482 had numerous exemptions held within it, such as single-family homes and condos and properties that were newer than 15 years of age, etc. Now, with the introduction of AB 3088, this indicates that all residential rental properties are to be impacted by this new language in the bill without exceptions or exemptions. So with the introduction of AB 3088, all 30 and 60-day notices of termination of tenancies have been stayed until February 1st of 2021. Now let's segue into some Q&A on a few of the questions I've received over the past few weeks, starting with question 1. If the tenant has not paid rent that will come due between September 1st and January 31st of 2021, will the landlord be able to evict the tenant on this basis through an unlawful detainer? The answer is generally no. The tenant will be required to pay a minimum of 25% of the rent for this period, but only until January 31st of 2021. For most tenants, the law only requires that the tenant fill out a declaration under penalty of perjury stating that they are unable to pay their rent or meet other financial obligations because of decreased income or increased expenses due to the COVID-19 pandemic. Practically, even if the rent is due and unpaid for, let's say, the month of November, the landlord would still not be able to obtain a judgment for the possession through the unlawful detainer process, since this amount could not actually be demanded until after January 31st of 2021. So the next question, which is related to the first question, is how is the landlord going to collect this unpaid rent? The landlord can go to court, including a small claims court. Beginning March 1st of 2021, landlords can take tenants to small claims court to recover unpaid rent, regardless of how much the tenant owes. The next question is, can the landlord ever collect this rent through an unlawful detainer process even after January 31st of 2021? With the exception of the 25% of the unpaid rent from September 1st through January 31st, 2021, The answer is no. To collect unpaid rent for this period, the landlord must follow the specific procedures as outlined in the bill. In general, rent for this period may only be collected as a personal debt unrelated to the possession of the property. The next question is, can a landlord serve a 3-day notice to pay rent or quit? The answer is not if the rent being demanded is for rent that came due between March 1st of 2020 and January 31st of 2021. It must be a modified 15-day notice that includes, among other things, a copy of a declaration of COVID-19 related financial distress. Next question. Is written documentation of the tenant's financial inability to pay the rent required to be provided to the landlord? The answer is only if the tenant is a high-income tenant, otherwise, no. High income is defined in the County of San Diego as a household that has a median income that is 130% or greater of the County of San Diego median income basis, which by the way of an example would be say a standard family of 4. They would be considered a high income tenant if the household made $120,510 or more. In this example, the tenant would be classified as high income and would be required to provide written documentation supporting their claim of adverse impact due to COVID-19. Well, what if the tenant fails to return a signed declaration within 15 days? Can the landlord initiate an unlawful detainer action then? The answer is yes. However, the tenant will be given the opportunity to submit a declaration within 5 days of receiving the summons that was sent to them, notifying them that they failed to return the signed declaration. The submission of the tenant's signed declaration is to take place at a hearing, and this hearing is to be separate from the unlawful detainer trial. Next question. Under what circumstances could a special penalty be levied against a landlord who uses illegal means to evict a tenant who has provided a COVID-19 declaration of financial distress? Well, when a tenant has provided that declaration of financial distress, penalty damages could be awarded against the landlord if the landlord attempts to perform illegal activities, such as interrupting or shutting off the utilities, changing the locks, removing doors, removing the tenant's personal property. These are all examples of illegal eviction tactics. So how much could the landlord be liable for? At a minimum, penalty damages of at least $1,000, but no more than $2,000 can be levied. And this would be in addition to existing penalties of somewhere between $100 to a maximum of $250 per day that the landlord is in violation. And in addition to that, the landlord could be held liable for actual damages and attorney's fees too. So the biggest question that I'm sure you're all asking is, well, when does this wonderful rent relief law expire? Well, the answer to that, and you're going to want to mark this on your calendars, is February 1st of 2025. So there you have it, a quick flyby of a rather complex law that has recently gone into effect. And although I'm not an attorney, I did receive some great guidance in preparing this video and sincerely hope that you found it helpful and informative. If you do have any follow-up questions, please let me know. Call me here at the office at 858-485-6565. And in the meantime, and until our next installment, all of us here at SDRPM wish you and yours the best. And please stay safe and stay healthy.